So one of the reasons we conduct this webinar, and you will see the webinar schedule that we have quite a lot of webinars coming with very short notice, is to give you an opportunity to raise your questions. And that's the reason we just want those who have questions and who are more interested in participating in a live seminar to enroll for this. So that probably explains why we have limited number of seats and why we have not kept it as an open webinar, and the reason why you have to pay. Many of you have already indicated to us that, we have already paid for the course, should we pay again? The answer is yes, because you are getting an opportunity what others don't get. And if you don't have questions to ask, then I would suggest that please follow the recording. The recording should do the job of telling you what we covered in the webinar. Now, let me try to cover the material. I mean, this is largely in the form of certain points. Initially, I drafted this as mistakes. I mean, that's how I and my colleagues drafted this key points. We developed it as the 20 mistakes to avoid. Now, rather than referring to it as mistakes, we can refer to it as certain 20 tips, or the 20 things that you need to know to do a much better job in your patent agent exam. Okay, now I'm just going to share a document, and you're just going to have a look at it. But though these are the best practices, or what I would say that you need to, these are the practices that you need to keep in mind. Bear that the detail is in looking at what you should be doing, given the fact that you just have less than 2 weeks time. Okay, now I'm going to share my screen and we will see. Okay, you may have to mute your mics. And hold on, I'll just share my screen now. Yeah, I've shared it. Yeah. Okay, here are the things that we need to look at. So these are the 20 tips to clear the patent agent exam. And we know that mistakes can happen. Most of you would have prepared very well, but while you are in the examination hall, there are certain things that you need to focus on. The first thing is to understand that the patent agent exam is a legal exam. It's an exam where you are questioned about the law. You may not have a formal legal background, but the examination, both part 1, paper 1 and paper 2, are designed around the Patents Act and the rules. So you need to know the law and you need to cite the law. So citing the law is one thing that you will always keep in mind, because by citing the law, you are going to demonstrate your proficiency in the law. So at the end of the day, the exam itself is to test your proficiency in the law. Okay, so ignorance of law is not an excuse, and the same is true for evasion as well. Leaving off the law is also not an excuse. So the legal provisions have to be mentioned. You have to mention the correct section, the rules, the form, and if there is something linked by way of fees, that also has to be mentioned. So bear in mind, when a question, especially a question in paper 2 comes your way, which is a situational based question, you have to link these 4 things. If there is a relevant section or sections, you need to know that. Then you need to know the connected rules to it, because most of the sections will have some kind of wherever the section has a detail, you will find it prescribed in the rules. Now, some of the sections would say that as may be prescribed or as prescribed. So whenever there is a prescription, the details will be found in the rules. So you need to know the rules as well. The section and the rules may manifest in a form. I mean, we have 31 forms totally, and you can use these forms for various proceedings. So one way to understand the form, I'll be coming to that soon, is that the forms are used in transactions. So when you want to transact something with the patent office, you want to deal with the patent office, that is when you will use forms. And forms itself are a great way to understand the section and the rules, because the forms do mention the section and the rules. Okay, so one of the ways you will remember the provisions of the act would be to look at the forms, and the forms at the top will mention the section and the rules, and use that tool, the form, as your point of study to understand the section and the rules. So this may itself be a way forward for a person to just look at all the 31 forms, understand or make a note on the provisions that are covered in the forms, both the sections and the rules, and to form a pattern. Like if you are going to refer to form 1, then what are the sections connected to it, rules connected to it, and what could be the fee. So if somebody can create a pattern or a tabular column which makes it easy for somebody, for a person to memorize, then that will hold you good, because this is what they want to ask, or this is what they want you to demonstrate when it comes to a situation-based question. You have to mention the section, mention the rules, mention the forms, and if there is a connected fee, that also needs to be mentioned. Now, the second thing, so the first thing you will do is to cite the law. Second thing is to keep track of the money, by which we mean that every transaction, now we just told you that all the 31 forms pertain to one transaction or the other. Now, those transactions may or may not involve money, in the sense that we refer to the word money when we want to remind you that there could be a fee connected with a transaction. There are some transactions where there are no fees connected. For instance, to file a pre-grant opposition, there is simply no fee. There is a form now, but there is no fee. Whereas for filing claims, amendment of claims, claims beyond 10, filing an application, all these things will attract fees. And fees, again, we know that there are different categories which can attract fees. The broad category is, if you're going to do a online filing, you have one set of fees. If you're going to do a physical filing, there are other set of fees. Within these, you have fees for natural person, you have fees for startups, you have fees for small entities and natural persons when they do it in combination, and then you have other category, largely the corporates and the big institutions. So, and these 4 categories also appear for the physical filing as well. So once you have all the 8 categories in mind, then you can develop a formula, and we have already given you a formula to develop. If you need to remember only one category, with which you can develop almost the fees for any other category. So keep the formula in mind, and keep the fact that hold on, I just need to, and keep the fact that once you memorize one of these 8 categories, you will be able to retrieve information with regard to any other category. So you need to memorize at least one of the categories of the fees so that you can get the others. So keeping track of the money is important, because the transactions where official fees is involved, you could have questions around it. Okay. Now, the third thing is that there are forms which you need to use, and for every transaction, you can say that there is a form. In fact, by the introduction of Form 30, there is a default form when no other forms can be used. Now, this raises the question that if there is a transaction and if there is something that needs to be done, should I use Form 30 for every transaction where there is no form? For instance, there are various transactions where you need to get in touch with the patent office, but there is no form available. So should you be using Form 30? Now, Form 30 is required where you need to get in touch with the patent office and there is a transaction involved. The formula is there in the video. You have to watch your video. I mean, it's there as a part of the course. Maybe if you have missed out on that video, you can raise it in the forum. We'll answer that separately. There is a specific video on fees, which will tell you what the formula is. Okay, questions at the end, please. I know you will get these questions, but keep it them, because once you put it in the chat box, I'll be able to see it. I'll be looking only at the questions raised after I stop my short lecture. So I'll take the questions at the end. So so when do you use Form 30? Now, Form 30 is used where there is a transaction and you don't know which form has to be used. So Form 30 requires an underlying transaction. And when I say an underlying transaction, I'm referring to a means by which the applicant can approach, or a third party can approach, the patent office. So inevitably, we are talking about a process by which you can approach the patent office either as an applicant or as a third party. So this requires a form. If the form is not prescribed, then you need to use Form 30, which means if you are writing a letter to the patent controller, say you want to just visit the patent office or interview a controller for just some academic purpose, you don't use Form 30, because that is a casual visit. You want some information from the patent office. Probably you just want to write up and meet up with some controller. That will not amount to a transaction. So understand that the communication, for that, the normal letter will do the job. You can just write a letter. In many cases, if you want some information for research, you can take an RTI. These are all not connected to transactions. So you need to understand forms and what we call forms and formations. By formations, we mean that there is a transaction, there is a give and take between the applicant and the patent office, or a third party and a patent office. So forms are connected to transactions, and by transactions, we refer to things that have to be done for which there is a procedure and for which there is a provision. So writing to the patent office, making an inquiry under the RTI, these are all not transactions under the Act and the rules, and you don't use Form 30. The understanding is that many a times you will see Form 30 and say that, okay, there is no form for this, it has to be Form 30. Yes, you use Form 30 provided there is an underlying transaction. If there is no underlying transaction and you just need to do, for instance, no, that may take us off the track, but if there is no underlying transaction, then your communication with the controller can be through a normal communication by way of a letter. Now, the fourth thing that you need to bear in mind is to link the provisions. Now, don't just cite the sections, quote the relevant rules as well. But when we say link the provisions, we are trying to bring out the picture where you can convey more information about your answer. So you give the entire scheme, you not only mention the section, you give the rules, and you try to impress on the examiner that you have the full idea about the subject. So they could be connected forms that you can use, they could be rules, they could also be fees. So in effect, we are telling you the same thing what we discussed in point 1, but the connection has to come out very clearly. Okay, how they are connected, how the forms are connected to the rules, how the rules are connected to the section. So here the emphasis is on the connections. The fifth thing may look mundane to some is to practice your handwriting skills weeks ahead. We have roughly 2 weeks now. And one of the things which I've noticed, which people have repeatedly told me, is that because they have a desktop job which involves typing, or because they have a job which involves no writing whatsoever, they find on the day of the exam that their hand stops moving. I mean, this is called some kind of a muscle reaction to sudden stress, because you're going to be writing many papers without having any background in writing, most of you, and you will find that you need to cover quite a lot of topic, and so some amount of writing can help, which means the best thing I could suggest is look at past years, look at granted patent applications, just start writing the claims. I mean, you'll get a hang of how the writing is, but you could also, and this, I'm suggesting this because of the number of people who have come and told me that they were not able to complete the writing part because their hands were aching. So the only thing I can suggest is just get into the habit of writing, because most of us don't write regularly, which is true for me. Apart from making short notes, it's been a long time since I've written a proper letter. So that's one of the skills that we possess, but we don't constantly practice. So and based on my interaction with past years, the earlier students who have taken the exam, I thought I should just mention this, that paper 2, which is a 3-hour written exam, is largely based on how you write. Okay, then the 6th point to be noted is that you need to, at this stage, you need to be reading quite a lot of specifications. And I would suggest that you focus on mechanical inventions, and the shorter ones are much easier, and you also feel good that you have covered it. And the idea is, the more you get exposed to the language of a patent specification, the better you become in drafting. So you have to be reading, I don't want to put a number to it, but you have to be reading different specifications on a daily basis. And there is no other way for it, because otherwise your writing will tend to be a technical writing. You will not get the nitty-gritties of drafting, which only exposure to good patents that are drafted will only give you that skill. Now, pace your preparation, again, may not be the best thing to tell you when there are just 12 days left, but still, you can still plan your, I mean, there are some people who do extremely well by just taking some time off and concentrating intensely on a project. I would say that this is the time you need to look at what should be your, on what you should be spending your time. Now, in the last webinar, we were asked, if you just have 20 days left, what should you do, or what is the most important thing to do? And we had written a blog post saying that you could be, I mean, if you are fairly good with the provisions of the law, then what you should be doing is taking the revision test. I mean, there are quite a lot of revision tests, and we have 26 revision tests and some 3 mock exams. We may have a couple of 2 more mock exams which will be done right in time. So the point is that expose yourself to a examination like situation, which are mock tests and a revision. There's a separate course on the exam practice course. So the more you do that, we feel that you'll be closer to putting yourself into exam like situations, and more importantly, you will be shown the answers. If you take a question paper from the internet, I mean, there are many floating around, the patent office itself has some, you will not be given a guidance as to how you did. Whereas our exams, which, because they are online, they will show you the correct answer at the end. So that's important, because every time you make a mistake, when you see the correct answer, you have an opportunity to correct yourself immediately when the mistake is fresh in your mind. So that's something which on pacing your preparation, I would personally feel that from here on, even if someone has not spent substantial amount of time in learning the concepts, could still take multiple exams and MCQ type questions and prepare for the exam just by focusing on the practice tests. Revise what you learn. Again, if you have been in the habit of making notes, that is going to hold you good, because on the eve of the exams, you can just look at the notes and quickly come up to speed on what you have what you have done. And revision is something which, as I said, as a part of taking the exam practice course, take the exam practice course multiple number of times. Even if you have done it fairly well, till you are able to get 75% of marks or more, which means repetition is going to be a key in revision. The ninth thing that we want to focus on is to clear your concepts. Now, concepts like priority. It may take some time for you to understand that priority is based on two things. It's based on the first disclosure, and it's also based on the point at which the disclosure got completed. So priority is based on when the information was published or disclosed first, and whether that disclosure was in itself complete. Meaning which, if the priority was staggered, then the point at which the disclosure got completed, the priority will start from there. Very simple concept, but once you understand this, you get it for life. So it may require watching some of our videos repeatedly, but still it'll hold you good, because certain things in law are very concept ridden, like novelty, for instance. How do you, the test for anticipation, the standard of obviousness from the viewpoint of a person skilled in the art. So the only way you can understand a concept is by repeated reading, understanding it, and clearing your doubts. But if it is some concept that you need to understand, I would say, like utility, priority, fair basis, anticipation, watching the videos till you get the concept could be a good way to move forward. Discussion with peers, we have helped you with that. We have a forum where more than hundreds of questions have been asked. Some of you have been active not only in asking the questions but also answering them. So the forum also lets you know at some level as to what others are doing. So we have a really vibrant forum, and we would want you to discuss it with your peers and take it forward. Clarifying the doubts, again, the forum is not only a place where you can discuss it, you can also clear your doubts. We are constantly watching the forum, and we are also answering things on the forum. And anything administrative, you can always write to us, but please use the forum, because forum becomes it becomes a place of record which people probably in the years to come can have access to. So we would request you to email all the administrative things, video is not working, audio is not proper, any administrative thing, you could write to us at contact or support@lexcampus.in, and please keep the forum only for clearing your doubts. The 12th thing that we would want to emphasize is the fact that patent drafting has its principles. There are certain principles on which patent drafting has evolved. One thing just to mention is the fact that the claims are still written in a single sentence. I mean, that's by convention all over the globe. Claims are still by convention written, though there's no legal requirement for that. It's written in a single sentence. So the principles of drafting will tell you, and we have been a proponent of the problem solution approach, wherein you look for the problem in the prior art and pitch the invention as a solution to the problem. And there are great advantages in it. One of the reasons or one of the ways in which patent officers look for the inventive step is to see whether it solved an existing problem. So this is one of the most sought after approaches in drafting, and you may have to look at the videos on drafting to understand what these principles are in greater detail. 13th one, I mean, I need not stress it now, but prepare for the examination first and worry about the viva later. We had many people who were more interested in focusing on the viva, but once you get the exam right, I am sure you won't have any problem with the viva. I mean, we could have sessions after the exam is over. Once your result is out, we could have special sessions on what to look at in a viva. The 14th point is to befriend the Bare Act. You have to have by now a close relationship with the Bare Act, and you should have the copy of your Bare Act should be look tattered. I mean, that's one indication, or it should be marked, highlighted, whatever, to know that you have used it, because the examination is completely based on the Bare Act. That's the act and the rules. You're not going to get any question out of it. There are certain principles of drafting which will come, but it's still the root is from the act and the rules. So, and even when you clear the exam, you will find that as a practitioner, you will need the Bare Act more than anything else. So before the Bare Act is to repeatedly refer to the Bare Act. For instance, you just do a practice test and you find a couple of answers, you didn't get them right, but then take that opportunity to look into the provision and reinforce your understanding about that part of the act or the rules. So the reinforcement should not happen by looking at some text or material. It should happen by looking into the Bare Act and understanding it. This is one of the reasons you don't need a detailed treatise or a book to clear the patent agent exam, because the Bare Act itself does the job. And if at all you need a written material or a book or a study material, it should be to explain the concepts. So you need something like, somebody has to explain you what anticipation is, what fair basis is. We need to explain the concepts, because the law is on which you will be questioned is already there in the Bare Act. Okay, the next one, 15th one, is look for success stories. Now, we have a couple of podcasts of people who have cleared the exam, and it'll be nice if you, when you get the time, to look at how they approach the exam. They have some significant insights on how they prepared, how they took the exam, the kind of frame of mind they had, and how they tackled the viva. This is just to tell you that, it's not a hard exam to crack, but nevertheless, we've seen that the pass percentage has been at the lower side. The 16th thing is that solved papers will not be entirely helpful. Now, normally, if you are been to college or to university, then your approach is to look for solved papers, because that's how we crack most of the exams. Look at all the papers for the past 5 or 10 years. Then, because essay type questions can get repetitive. So if you have taken an examination, you could have some amount of repetition that comes over a period of time. Now, one of the reasons we don't recommend solved papers as the main approach is the fact that the law has changed substantially since the last 3 or 4 years. The last exam was conducted in 2016, the one before that in 2013, and the law has changed. We have had amendments to the rules, multiple amendments. In 2016, we had an amendment. There's been an amendment in 2017. And we've also had, since 2013, there's been quite a lot of change introduced into the Act. So apart from that, Patent Office also ensures that there is not a great deal of repetition in the exam. If you see that there are certain topics which we can say are important, but the situation-based questions and the drafting questions are never repeated. Now, you should bear this in mind. Paper 2, what you are going to face in Paper 2 will not be something that has been repeated in the past question papers. Looking at the past question papers, you will get to know the structure of the question, how they ask questions, the type of answer that you may have to give, but it will not get repeated. So that's yet another reason why we say that you should not focus too much on the solved papers. Looking at the solved papers to look at the structure of the question, the pattern of the question, what is expected of you is fine. But again, as I said, the law has changed, and the Paper 2, as we have seen, comprises of situation-based questions and drafting problems which are not repeated. 17 is watch till you learn. This is something which, again, from some of the podcast our earlier students have done, is that in today's world, a video lecture may be a much easier way to digest some bit of information, especially if you are traveling, say you have a long commute from work to home. This could be a thing. And what we have done now is we have shorter videos on the courses page. So if you want to look at a shorter video, all the lessons have now been split. Most of them have been split. So somebody who needs to access the videos alone, the shorter format is available now. So you can take a look at it. There's no need for you to subscribe for the entire course. If you had done it earlier, it would have done you good. But if you are just looking at shorter videos by topic, you can look them by topic and you can watch them. 18 is the fact that this could be the best time to clear the patent agent exam, because the examination was not conducted last year, and there is a possibility that in the coming years the examination will get more complicated. And as you know, in the United States, it's an open book exam which can be taken anytime. So we are still not in that stage. It's still a closed book exam in India. And I feel that as the subject gets more complex and the practice gets more complicated, we may move to an open exam, and things will become much tougher, because then the level at which you need to prepare will also be different. And the fact that the patent office has recruited quite a lot of people now easily there are more than 1,000 people working at the patent office, both examiners and they've been on a recruitment drive. The patent office is now giving out first examination reports, which means it is now examining and giving reports on examination much quicker than they ever did, because the patent office has not been staffed so well at any point in history, which means there will be a corresponding requirement of patent agents. So the patent office has done its job of increasing the manpower, and I'm expecting that the number of people who clear the exam this time will be more, for the sheer fact that there'll be more people taking the exam, and also the underlying fact that we need more patent agents. So there has not been another time since independence where India has needed so many patent agents, because of the rate at which now applications have been disposed of. So this could be your time. The 19th point is to focus on simple inventions. I've made this point earlier. If you have some domain expertise, say you have a chemical background or you have an electrical background, the tendency would be to focus on things from your area, your domain area. But if you look at the past question papers, you will see that there has always been a question on a mechanical invention, a simple invention, and they could be as a choice, there could be a question on biotech, pharma, or chemical or electrical. So you are going to get a question on simple inventions, largely mechanical. So it would be better if you could focus your preparation on simple inventions. So if you could prepare using simple inventions, then it's going to make your preparation much easier and you will not be taken by surprise. So rather, if you only focus on pharmaceuticals, for instance, or only on biotechnology, because that happens to be your area, you may miss out on certain things on how simple inventions are drafted. So focus on the simple inventions. And the last point, the 20th point, is to manage your time well. Now, how does one manage their time for the examination? Now, before you go for the examination, especially paper 2, and I've seen many cases of people not clearing paper 2 because they managed their time badly and they fell short by 5 marks or less. Very tragic situations, and people whom I thought will definitely clear were into this situation because they got carried away in answering a particular question, or some questions they ended up spending more time than what actually was required. So you need to have a mental picture of part A, B, and C. What are the marks for part A, B, and C, and how much time you're going to allocate for A, B, and C in paper 2. Paper 1, I've seen that most of you will do it before time, and I've known from past experiences, paper 1 is normally cleared well ahead of time. It's a manageable thing. But time management is critical for paper 2. And in paper 2, there is part A, B, and C. Part A, I understand, is for 25 marks. Part B for, okay, 20. Thanks for the correction, Venkat. It's 20, 30, and 50. So the time you're going to spend has to be in that proportion. It has to be in the proportion of 20, 30, and 50. And understand that the time you take for reading should come within this time. So you apportion the time. I know certain people who will first read the entire question paper and then see what they can. If that's your approach, well and good, but still you should not spend more time on a segment which will not get you more marks. So your planning or your time management should correspond to the marks allotted. So that's a simple thing to do, but bear in mind, I know many people who have finished their PhDs and could not manage their time well. So I'm telling you again, and it's not a great thing when you are scored more than 70 in your paper 1 and you just fell short 3 or 4 marks in paper 2. I mean, it's a tragic situation. Just to reiterate that, you should not get into that, and you should try your best to ensure that the time is managed well. And again, it's left to you whether you want to read the questions first or allocate time and read them within the allocated time. But know that no matter how well you draft a patent in part C, you will not get more than 20 marks because 25 is the maximum marks for it. So you are looking at something for say 45 minutes. If you want to give 45 minutes for drafting one specification, then no matter how much time you spend, you're not going to get more than 20 because 25 is the maximum mark. So bear this in mind and use your time smartly. Okay, we have more webinars coming up. We have one on Thursday, and then one on Saturday, and Monday, Tuesday, and Wednesday. We'll be taking up situation-based questions. So if you have a situation-based question that for which you don't find an answer and you want us to discuss it, you can email it to us. Not posted on the forum, contact or support@lexcampus.in. We will discuss that, but please try to avoid questions that have been raised in past question papers. It should be a genuine question which somebody has created and you don't know the answer or you want us to discuss. Please email them. We have them coming up, I think, on Saturday and Monday, so we will take it up then. And now, if you have any questions, I can start answering them. Okay, good question. The first question is on how many forms are there to memorize. Okay, there is a shortcut for that. Okay, now with regard to forms, you can. I hope you have your Bar Act with you. You have to befriend the Bar Act, as I said, and at least till the exam is over. Now, if you look at the second schedule, second schedule, there is this forms, the list of forms. Now, second schedule will come after the rules. You have the first schedule, which is the fees. The second schedule. If you have our Bar Act, then it's page 156 of the LexCampus Bar Act. Now, here you have a list of things put. There are 30 forms. If we have 30, actually we have 31 forms. Well, you have 7 and 7A, which makes it 31. So all these forms are important because they pertain to some transaction or the other, but there is a nice way in which you can group these forms. Okay, now look at the first two forms. They pertain to filing of an application. You simply can't file an application without Form 1 and Form 2. The third form is a statement of undertaking, which has to be done after you file the application. So you can see that statement of undertaking with regard to international filing, with regard to foreign applications, corresponding foreign applications. Number 4 pertains to any extension of time. You want to extend the time for doing something, then you have to do that. And 5 is on declaration of inventorship. Now, if you group 1 to 5 as one category, you can say that these are the forms that a person will need to file immediately on filing an application or soon afterwards, because declaration of inventorship, statement of undertaking are things that you need to do quickly, soon afterwards. Request for extension of time is an kind of an outlier, but you can factor that. You can factor that because sometimes you may have to take a request for extension immediately. You know, you may have a 6 months to file something and you can still take during that time. Now, form number 6 onwards talks about if there is a change with regard to the applicant, then you can do that. So 1 to 5 is something which you can think at the first go, you need to use those forms. And after that, there are some change needs to be done to the applicant's name. So you can think about form 6 as something that you file while changing the name of an applicant. And form 7 and 7A pertain to oppositions. Okay, know that 7 and 7A are in the law 25(1), that is pre-grant comes first, and 25(2) post-grant comes afterwards. But in the forms, the post-grant forms comes first, that is form 7. 7A, the pre-grant form, comes later. So bear this in mind because pre-grant, there is history behind it. Pre-grant could be filed even without forms. But in the new amendment, that is in 2014, we introduced the form 7A. So pre-grant earlier could be, you could just send a letter. There was no particular form. You could send a letter to the controller with all the prior art. Some people drafted it like a petition, but you could just send it. You could just send it. So in 2014, they introduced a form. So 7 is for post-grant, 7A is for pre-grant. So there is a slight tweak there because of the history. And then 8 is again a connected matter, because if an application is filed and someone feels that they were a part of inventing that invention and their name was missed out for whatever reason, you could mention as an inventor. So to be mentioned as an inventor, you could take form 8. So that's again, it continues soon after something which a person, if he notices an application has been filed and not mentioned as an inventor, form 8 comes soon after you are still in the application state. Soon after application. Now, what happens after an application is filed? It gets published after 18 months. If you are in a hurry, what will you do? You will make a request for publication. So there we have form 9. Form 9 is a request for publication. And what happens after you take a request for publication, early publication? If you take a request for early publication, the application is published and you need to take a further request for examination. So if you make a request for publication, you also have to follow it up with a request for examination. Now, 9 is request for publication. You double 9 into 2, 18 is the request for examination. So 9 and 8 are related. We know it's related, it's double of it. So remember 9 as a request for publication, early publication. If you don't take 9, it automatically gets published after 18 months, but then you are not in a hurry. Okay. Because you are in a hurry, you can take 9 and 18 together. It's possible that you file 9 and 18 together because you are interested in getting this published and getting this examined. So 9 2 times is 18. So you can find that link there. And 18A is expedited examination. So 18 is examination. Why is 18 examination? Because 9, which is half of 18, triggered it. You filed an early publication, request for early publication. So publication and examination are related. And thankfully, they are also related by some number scheme. And 18A is nothing but expedited. It's a type of examination. If 18 is examination, 18A is a type of examination, which is the expedited examination. Now you have between 9 and 18, 10 you have application to amend a patent, that is upon death of a party. That is different from the application to amend under 13. So 10 and 13 both may carry the word amendment, but in 13 you're talking about the broad amendment which you can do under 57. Okay, whereas 10 is about amendment pursuant to a person's death. So bear that distinction. 10 and 13 are both amendments, but 10 is an amendment for a person who dies. His name has to be, his legal representative has to enter the records. And 13 is for section 57 type of amendment to claim, description, drawing, abstract, any amendment. The substantive amendment is covered under 13. And that leaves us with 11 and 12. Now, 11 is an application for direction of the controller, where there are many owners, co-owners. 51 is co-owners, yeah. And 12 is request for grant of a patent in certain special circumstances mentioned in section 26. So these are not often used, and you don't, these are not the forms that are often used, but you can just make a mental note. 13, as I said, is the most important form because every amendment has to be done by using this form. So 13 is the form for amendment, so you will not forget that. Similarly, 14 is very important because 14 is the form that you use for opposition. And there are multiple types of oppositions under the Act. We have a separate video on that. Please watch it. You can oppose an amendment. You can oppose the grant of a compulsory license. You can oppose surrender. You can oppose various things under the Act. And you have the common form for that, whether it is pre-grant, post-grant opposition, notice of pro, or any other opposition. You are going to, somebody's mic is on. Please mute your mic. We are getting some disturbance. Please mute your mic. Okay. Okay. So that's 14 for you. Now, 15 is for restoration of patents. If a patent is lapsed, you can use it to retrieve or restore the patent. And 16 with regard to registration of title or interest in a patent. Wherever there is a title, a transfer, a mortgage, or anything, you use section. Yeah. Somebody's mic is causing some disturbance. Hold on. Yeah, thank you. Yeah. So that's 16 for you. So any registration of title, mortgage, transfer, sale, lease, anything pertaining to it, you're going to use 16. Now 17 onwards, okay, you have to do a small jump in 17. Now 17 is application for compulsory license. 18 and 18A, we covered it. It's with regard to examination. Now after 17, you can jump to 19. 19 is again compulsory license. 20 is again compulsory license, and 21 is again pertaining to compulsory license. So 17, jump over 18 and 18A, 19, 20, and 21 all pertain to compulsory license. So you can group them. The reason I'm telling you this is so that you can make a scheme in your own way, which is easy to recollect. Okay. So what would happen after a patent is granted is that you can file for a compulsory license 3 years after a patent is granted. So this is where we understand after everything is done, you can look at compulsory license. So now we finished Form 16, and now we are looking at, because Form 16 again is triggered when a patent is granted. You can assign a right, you can transfer a right, sell a right when the patent is granted. Similarly, Form 15 can be used after the patent is granted, because you're only worried about restoring patents that are granted. So 15 onwards, you could say, are post-grant. 15 onwards is pros grant. We have that exception of 18 sitting there because 18 was like 9 into 2. There's another logic to explain the 18, because believe me, the forms were not inserted keeping patent agent examination in mind. So that is why you have this chaotic order, but we'll try to make sense of whatever is there. So 15 onwards is post grant. A patent that needs restoration happens after the grant, and 16 is registration of title. That is again something that happens after the grant. 18 and 18A we kept it aside because of the publication and the examination thing. Now 19, 20, 21, 19 talks about revocation of a patent for non-working under section 85. Very rarely used provision, never used in India. It's largely academic. It's a very onerous provision also. So you may not be asked that. It's a very rare thing, but that gives the right to revoke a patent after a compulsory license is granted. So you can ask for revocation of a patent because compulsory license is actually sought for to address a calamity or to address a issue in the law. The law was not functioning. There were people who were in need of, say, a patented invention. They could not get it, or it was not affordable, and it was not worked on a commercial scale. To address that, you file a compulsory license. Now, even if the compulsory license is granted, it still doesn't serve the purpose. Then you can ask for a revocation. So 85 is a revocation after the grant of a compulsory license. So it's an extreme step, because some people believe that compulsory license itself is an extreme step, but there is another extreme beyond the compulsory license. That is, if the compulsory license is granted and it is still not worked, you could ask for the revocation. So 85, we understand section 85 as linked to form 19 as an extreme case where after the compulsory license is granted, it is not worked. So you can ask for a revocation. 20 is revision of terms of the compulsory license. So compulsory license is already granted using form 17 and you want to revise the terms, you use 20. 21 is for the termination. So you have application of compulsory license in 17, a revision of terms in 20, termination of the compulsory license in 21. Now 22 onwards, you have various mixed stuff here. So 22 is something you all should like, because after you clear the examination, you're going to use 22. Okay, you're going to use 22 because that is how you're going to apply and register yourself as a form 22. So if somebody asks you, which is your favorite form, you should say 22, because if I use 22, I become a professional. So 22 is your favorite form. Okay. Now 23 is restoration of the name in the register of a patent agent. Now assume that you become a patent agent and for some reason you forget to pay the renewal fee and your name gets dropped. You can restore your name. So 23 is connected to 22. Your name gets dropped, you can restore it. 24 is whenever the controller passes an order under section 15, under section 25, 1, under section 25, 4, there is a opportunity to review the order. So if you're not happy with the order, something is left out, the order does not make sense, there is some ambiguity, or wrongly it mentions instead of saying should not, it says should, some grave mistake, we want to bring it out, you can file a review. Now review is normally done to not to correct clerical errors, because clerical errors and typos can be corrected by the controller itself, but this is being done to make the controller look into the matter again, what he has already decided. So review is the power of the controller to review his own orders, can be done by taking an application under 24. Now 25 is important because they've been almost, since I can remember, there is almost some question around section 39, because section 39 requires a person to take permission before filing an application abroad. If they want to file an application abroad and they are resident in India, they have to take what we call the foreign filing license, or for permission for foreign filing, and that is done by using form 25. Form 26 is again after Form 22. Form 26 will be the form that you love the most because that will bring you money. Every time you file Form 26, you are representing. This is more like what the wakalat for advocates, right? To enter appearance for a client, the advocate would file a wakalat, an authorization before a court of law. The Form 26 is the kind of the power of attorney, because at some point we were also appreciating power of attorney instead of the Form 26 itself. So Form 26 is actually drafted like a power of attorney. It gives the agent the right to represent as an agent um, for the person, for the applicant. And that is 26. Okay, so 26 and 22 are connected because in 22 you become a registered agent, and in 26 you start doing the business, you start earning money. 27 is a form that has been in the news, which is currently being litigated. There is a Delhi High Court case right now pending on the requirement of filing Form 27. So Form 27 is topical, so you can expect a question on Form 27. Form 27 requires applicants to file working statements at regular intervals. You will find the section tied to it is 146 and the rule is 131. You can have a look at it. And this is in the news. You can do a Google search and find out the working requirement in India. People have written extensively on that. It's topical, so you need to bear that in mind. 27 requires applicants after the patent is granted to file statements on whether they worked the invention. And it's a subject matter of litigation in the Delhi High Court. So that's another reason why you should keep track of it. Now, 28 and 29 were introduced. 28, 29, 30, they were all introduced recently. So 28 is a simple form. Now, any question on startup, claiming the benefit of a startup or a small entity, you have to first demonstrate that if you are claiming a benefit of a reduced fee structure. If you're filing it as an independent natural person, there's no need for you to file any form. But if you're going to claim the benefit of a reduced fee structure as a small entity or as a startup, you need to file Form 28. So any question on startup, bear Form 28, because Form 28 is how you are going to demonstrate that you are a startup. And startup has only two things that are different from a normal applicant. One, there is a reduced fee structure. Two, there is a possibility, if the startup avails it, for having expedited examination. That is 24, Rule 24C, capital C. Okay, capital B is normal examination, capital C is expedited examination. So startups have these two things. Once you prove you are a startup, which you have to do by filing Form 28, you can avail a reduced fee, which every startup will get. And if the startup is in a hurry, if it wants the patent granted quickly, it can also go for expedited examination. Other than that, startups are just like any other entity. 29 is again a recently amended form. It allows an application to be withdrawn with a refund of fees. So you will find the refund of fees if you just move one page before the last column of first schedule. There is a table called Table 2 Fee Refundable. Okay, so this is under 7.4a, and 7.4a is mentioned in 29. So you use this form for withdrawing an application, and in some cases you may also get a refund of your fees. Form 30 is a miscellaneous form, which I mentioned, which can be used when there is a transaction but you don't know which form to use. Okay, now let me come to the questions again. Now I just gave you a rough estimate on the important forms and how to memorize them. How to score marks in Part C of Paper 1. I'm losing most of my marks in Paper 1, Part C. Oh, okay. Part C, I believe, are the multiple correct answer. Yeah, Part C of Paper 1.
Part C is the multiple.
Yeah. So okay, multiple options. Okay. One way to do that is to be a bit more thorough, in a bit more thorough in your preparation. See, we knew this could be a problem. You have raised it, but we knew this could be a problem. That is the reason every revision test of ours is multiple answer. So we have set the default at the high level so that you get trained for it. So the only way you can do that is to repeatedly expose yourself to answers that have so all our 25 revision tests and the mock exams, we have made a disclaimer right up front saying that more than one answer could be correct. It just comes by more preparation, and the more you visit it, the more you become conversant, and hopefully you should be able to do that. Yeah, the fee memorization video, that's the YouTube video. We also have one on for the paid subscribers on LexCampus. We have another video. So this is just the free video that you can watch, but you will still get the formula. Can we attempt part C first? Now, I don't have any, that's your call, whether you want to write part C of paper 2 first. But the point is, at the end, say, if you're going to take part C first, you have 150 minutes allocated for it, or 1.5 hours, sorry, 1.5 hours allocated for it. And what you would do is you have to have a 45 minutes split between the two questions. So if you are taking it first, be very clear on the 45-minute mark that you have to stop and move to the next question. No matter how well I can write even 3 more pages on paper on the first question in part C. Still, at the 45-minute mark, please move to the next question. That's my only thing. You have to. What you do first is not important, but how you do is more important. So at the end of 45 minutes, you have to move to the next question. That's more important than what you face first. That's completely left to you, what you want to do first. But the tendency is that if you the patent the people who are examining your papers will get an impression that as the paper moves forward, the quality of the answers will go down. And I've seen this because I'm still conducting courses and correcting papers. I see that the danger of not following the numerical sequence in which the question paper is that you are telling the controller or you are telling the examiner that I write my best answers first. And as your paper proceeds, the examiner's interest and the level of engagement in the answers would go down. Rather, if you follow the normal numerical sequence, then a good answer can come anywhere. So he will not be prepared for this. Otherwise, and I've actually seen this, the answers towards the end are the not so good answers. So you can actually get the benefit shifted in your favor if you just follow the normal sequence. Anyway, that's, as I said, it's a matter of personal choice. Okay, there is 1818. Okay, we have dealt all that. Please, grouping of forms together, there is no particular video. I just mentioned it now. So when we make a video out of this, that's the video for you. Okay. How come how much 4th and 5th schedule is the international fees? So it'll be good if you have it's not a very exhaustive schedule, but it's just something that you need to bear in mind. The 4th schedule is with regard to cost. It's something that is asked in practice, and cost is not the norm. Okay. When there is a proceeding between two parties, one party succeeds, the other party fails, the succeeding party can actually ask for legal cost. So it's a rarely used provision. There have been few cases where the controller has awarded cost. I don't expect that to be one of the pain points. Rather, 4th schedule is very important because that is where the questions can come from. 5th schedule, there could be a question. I'm not ruling that out, but again, it's not, the details are not as you find in the 1st schedule. Okay, the fees. So the 4th and 5th, if you ask me, they're not really important, but knowing them, having some amount of familiarity will help. Don't worry about the appellate board rules, because appellate board rules is actually out of syllabus. Okay, it's out of syllabus because if you see the act and the rules, that is what is your syllabus. It's out of it, but having some broad idea about it can help. Maybe they could ask you some question in the viva, but I don't see any question on the appellate board rules being asked because that will make it out of syllabus. The focus should be on the first schedule. The focus should be on the transactions. See, there are quite a lot of forms mentioned. So, what should be the fee in the 15th year of renewal? Don't bother about it. Okay, as long as you know that there is a different fee structure for the 15th year, don't bother about it. But what you should be worried about is every like while filing an application, if there are more than 10 claims, there could be a problem asking you to compute. They will tell that there are 20 claims. Now you have the math with you, you can come up with the number as to how much extra the client needs to pay. Okay, so you are going to look at the main forms that we mentioned and focus on that. I don't think you need to memorize everything. Just focus on the main forms, the ones that are used in transaction. Yes, 32 forms. Yes, 32. Correction. Yeah, it's 7 and 7A. Thanks for the correction. It's 32 forms, not 31. There is no live drafting course that I'm planning to offer, for the simple reason, live drafting course, no matter how long we have it, we cannot cover it. And I've done this in the past 2 years ago, and it's not, there is some benefit, but I always felt that an online course will be much more fruitful, wherein you can come back and watch it again. And the online course that we have here is also, there are built-in exercises which you can try and test. We may have a drafting webinar where we clear some doubts on drafting, but I don't, a webinar, a live course. Yeah, hacks. We have a pattern drafting hacks webinar coming up, wherein which some shortcuts will be taught to you, so that you can quickly, for instance, as I said in the last webinar, one way to draft an abstract is to summarize your claim, not reproduce your claim, summarize your claim. So that's one quick way to do that. So we'll be looking at the hacks in the forthcoming webinars. Okay, that brings us, we have already shot beyond our time. What I suggest, I can see some of you are raising some more questions. So if you can just raise them on the forum, we will answer them, and we'll be happy to answer them on the forum. So please use the forum, and we've already passed the time that's been allocated. We'll take that up in the forum. Thank you.